before you the notice of motion dated the 23rd of October 2023. Sorry.
Good afternoon, Your Honor.
We seek your custodial orders for 30 days against the 3 respondents. It's premised with the grounds in the page 2 application. I'm going to summarize just a few. There are quite a number of grounds. Your Honor, which was reported with this year, inquiry file number 457, Your Honor, in possession of fake land titles to the said property, reference to count 3. This was carried out with forensic analysis, which had previously been carried out dated 24th of February 2014. Your Honor, on the 9th of October 2023, in a civil suit, Machakos ELC case number 74 of 2014, which was consolidated with ELC petition number 10 of 2018, several respondents suing as officials of Aimilam, the Kenya Society versus East African Portland Setting and the Chief Land Registrar. Judgment was delivered by the court, and the plaintiff's suit was struck out to the defendant. That as a result of the said judgment, the court order, EAPC began demolishing all the permanent and semi-permanent structures on the said property, citing illegal demolition and land grabbing. That this case, Your Honor, has caused both political and public interest on innocent purchasers of the said property worth millions of shillings. Your Honor, the investigators have commenced an investigation into the said acquisition of the titles, and Your Honor, they are at a preliminary stage, and they need time so that they can be able to collect the evidence needed and have them verified. There are several subdivisions which have been done on the same property, Your Honor. All these are contained on the grounds, Your Honor, from number 9 all the way to number 19. Your Honor, the verification of the records are required to be done at the Registrar of Societies, Registrar of Companies, the National Registration Bureau, the Society of Kenya, Financial Reporting Center, the County Government of Machakos, Director of Surveys, and the Deputy Registrar of the Machakos Environmental and Land Court, among others, Your Honor, so as to establish the lawful and bona fide owner of the said parcel of land. Your Honor, the respondents were arrested on and during that period, Your Honor, the IOs have not been able to finalize the investigation. Since this is a case which is touching on quite a number of parcels of land and various investigations have been done. The number 51, Your Honor, measures approximately 4298 acres and is valued about 14,117,000,000 Kenya shillings. Your Honor, the said application is supported by the affidavit of one Detective Corporal Nicholas Osuri Otieno, which is annexed to the application, Your Honor. And we have also annexed all the required annexures in regards to the reporting and the preliminary investigations which have been carried out. Your Honor, the applicant needs the respondents to be in custody so that they can assist in some of the investigations. Your Honor, the applicant is apprehensive that if released on bond, Your Honor, might not be available or might abscond to court before investigations are concluded. They also believe that it is also in their best interest for them to be held in custody because of the volatile situation on the ground, and for their safety owner and for him to be able to finalize investigations. They will be remanded at Muthaiga Police Station for a period of 30 days to enable the IO finalizing the investigation. That is it.
Upon receiving from social media a letter requiring them to go and explain their role in the matter of this land, LR number 10424. They got the information of 24 Mavoko, which is registered in the name of Aimi Malokenya Society. So when they appeared before the DCI, they recorded their statements, and they were assured that since investigations were ongoing, they would be called again on Thursday this week to go and record further statements. So we were shocked and surprised that in spite of that assurance, the DCI came and arrested them within 2 days of recording their statements, and we don't understand the urgency of arresting them because they were not a flight risk. These are leaders of an association which has over 10,000 members. They brought themselves before the law as and when they were required. They complied with all the conditions, and they were willing to go back, and they are willing to go back as many times as they are required. So the urgency in arresting them, when the DCI is now telling the court that they have not completed the investigations, is not understandable, because no reasons have been given as to why now they have become a flight risk. We understand the investigations are ongoing, but then we do not see any justification in arresting them in the first place. They should have completed the investigations. My clients are well-known people. They have families here. They have permanent residences. They have no reason to flee this country. In fact, I don't think they even have passports, as would make the DCI apprehensive that they are a flight risk and require that they be detained in a police station for 30 days. But we do not understand why they are in custody. They have not been told when to go back, and they have not refused. They have not shown any indication that they are not going to cooperate with the DCI. Secondly, Your Honor, the question of ownership of LR number 10424 is a matter that is actively before the Court of Appeal. And in that regard, the Court of Appeal has issued directions in our civil application number E476 of 2023. Julius Mutie Mutua and others versus East Africa Portland Cement Limited. The matter was certified urgent by the duty judge of the Court of Appeal, and we are awaiting appointment of a 3-judge bench. We have directions. We have already filed. We have served the other parties. We have already filed our submissions. The respondents in that application are supposed to file submissions in 3 days. So we do not know how the process in the Court of Appeal, if there is conspiracy to defraud East Africa Portland, and my clients who are the respondents here are already contesting the issue of ownership with the same Portland at the Court of Appeal. We do not see how the charges of conspiracy to defraud would come in when that question of ownership has not been finally determined by the Court of Appeal. And for your information, Your Honor, the High Court matter in Machakos, number 74 of 2014, was struck out on a technicality. it was not heard on merits. There has never been a full hearing of that case. The Honorable Judge of the Land Court found that the lawyers for Aimi Malukenya had not complied with court directions to file an amended plaint within the time that was given by the court. So essentially, there was no final judgment as to even warrant East Africa Portland Cement to start demolitions of those structures on the land when the same parties are in the Court of Appeal. Thirdly, Your Honor, and you can see we have not even been served with this application, we want to say that Article 49 of the Constitution is very clear that an arrested person has a right to be informed promptly in the language that he understands of the reason for the arrest. What the prosecution has not told this court is that last evening, the suspects were shown by the DCI a charge sheet, and they were told to sign a cautionary statement. So this morning, they were coming to answer the charges they were shown. How it has all turned that now investigations are not complete, we do not understand. They signed yesterday. They were shown the charges. 4 charges, actually, including the charge of conspiracy to defraud. Now, where that charge sheet has gone overnight to justify the bringing of this miscellaneous application is not clear to anybody. The same Article 49, F of the Constitution requires that an accused person should be brought to court as soon as reasonably possible. The accused persons here were arrested on 19th. The investigators had the whole long weekend to call suspects to sign the cautionary statement. 149G, the Constitution requires that an accused person during the first appearance at the court appearance to be charged or informed of the reason for detention. They have not been charged. We are now being informed by an application which we have not been served, the reasons for the detention, which reasons have been given as investigations are ongoing. So if investigations are ongoing and my clients have not shown that they are a flight risk, we do not understand why they should not be released and recalled when the DCI, when the investigators are ready, even if it takes a month or 2 months. Our clients have no reason to flee the jurisdiction of this country. And as I've already said, they don't even have travel documents. And more importantly, Your Honor, Article 49H says that an accused person has the right to be released on bond. This is a constitutional right, or bail, on reasonable conditions, pending a charge or a trial, unless there are compelling reasons. Your Honor, we have not been given any single compelling reason as to why the accused persons should not be released immediately, or if need be, to be given bond on very reasonable terms as the Constitution requires. Your Honor, here we are dealing with the liberty of a Kenyan citizen, and Article 29 of the Constitution recognizes the fundamental right to freedom, and it says that every person has the right to freedom and security of the person, which includes the right not to be detained without trial, except during a state of emergency, in which case the detention is subject to Article 59. We have no grounds whatsoever laid before this court to show why the accused persons should be held in custody for a whole 30 days to allow the investigations to be completed, when indeed they voluntarily submitted themselves to the investigating officers. They were not even summoned. There were no summons. They were not compelled. They only answered to a message that was publicized in social media and in the normal media. And they took themselves. And they were ready to go back there. They have given all their numbers to the investigating officers. And we do not see any justification in the 30-day period. We can quote, without spending a lot of time, the case of Republic versus Danson, Mgunya, and another. It is 2010 EKLR, where Ibrahim J, as he then was, stated as follows regarding the right to liberty. He said that liberty is precious and no one's liberty should be denied without lawful reasons and in accordance with the law. Liberty should not be taken for granted. I will never take liberty for granted, and I know neither Dr. Camino, having both experienced the meaning of detention without trial and solitary enforcement at committee prison during the struggle for second liberation, suffered. We must interpret the Constitution in enhancing the rights and freedoms granted and enshrined. Is an application that seeks to unnecessarily curtail the freedom and liberty of the respondents to this application. And we have already said that there is no justification whatsoever. As I finish, Article 21(1) of the Constitution also imposes on this court and all state organs the duty to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. Your Honor, the respondents herein are law-abiding citizens. They are leaders of a community association. They have claimed ownership of this land, and their claim is still being litigated in court. That question, until it is finally determined, no criminal charge can be preferred against any of these persons. Because indeed, their prosecution is a prejudgment of ownership of that property. And we do not know, if they are being prosecuted, what the Court of Appeal is supposed to do to the appeal pending before it, in which the same question is being canvassed. Finally, Your Honor, before I give my colleague 5 minutes to sum up, one of the accused persons, Mr. Pascal Iseli, has a chronic condition which requires medical attention and continuous taking of medication and diet at specified periods of time. And in the last 3 days, he has suffered immensely. He cannot get the diet he's supposed to eat, cannot get the medication he's supposed to go through. So if you are going to put him again in 30 days without even telling him what charges he's facing, we think the prosecution is effectively threatening the life of a Kenyan who can be left free to be attended from his home. He has nowhere to go. His phone number is all over. He can be tracked 24 hours. And that applies to the other accused persons. So we plead with this court to exercise its constitutional mandate and reject this application as a scheme to oppress and torture the respondents and also to prejudice the proceedings that are pending in the Court of Appeal. I thank you for giving me that time, and I want to ask my colleague, Mr. Kala, to just sum up.
In fact, what they are doing amounts to misuse of the court process, because the accused, they had all the time to investigate. This matter has been alive since 2014, as you've heard from themselves. Your Honor, the accused persons were arrested on, the respondents were arrested on 19th, 4 days ago, on Thursday, up to today. The investigating officers knew that they had lawyers who were on record representing them, because we were with them at the police stations, at the DCI. But they didn't even have the courtesy to have us served in advance. Because yesterday we were preparing ourselves for plea taking, because we had a charge sheet ready that was signed, the cautionary statement signed by the accused persons. Now these amounts to total ambush, whereby they change goalposts at their own convenience. Your Honor, we invite this court to stamp its authority and score a goal for the rule of law, where even if we engage with state organs, the rights of every Kenyan must be respected and not trampled upon, Your Honor. Article 159, 2 of the Constitution invites this court, when in exercising your jurisdiction, to do so within certain set parameters, which include upholding the principles and values of that Constitution. Your Honor, the framers of this Constitution, 2010, did not make any mistake, and they did not do it for fun, to enact Article 149 to protect the rights. 49, not 149, 49 to protect the rights of any accused person. It was not in vain, and that has been, we don't want to repeat the same. So, Your Honor, we pray that the respondents be released unconditionally until the DPP, the prosecution comes up with charges. In the alternative, the charge sheet that was prepared be produced, and we are ready to take plea. Because we cannot just engage in games. Since morning, Your Honor, even the miscellaneous application itself, if they knew that they were presenting since morning, nobody had even the courtesy to even supply us with a copy or even inform us. We have been here. So if we allow this, Your Honor, then it means then we are abrogating our duties in terms of the judiciary, whereby you are supposed to be the custodians of the rights of Kenyans. Your Honor, the accused persons, as you've been told, are well-known people, and they're not flight risk. That one I will not labor to get. East African Portland is a state corporation. The accused persons have no capacity whatsoever to threaten a whole state corporation. East African Portland, that being one of the reasons that it's being advanced that the accused, that respondents should not be released. Of being officials of Malu, Kenya. They are not here in their own personal capacity. Your Honor, The respondents don't work in the lands office. The respondents don't work in the county government of Machakos. The respondents don't work in East African Portland. Your Honor, we fail to understand how they are going to interfere with investigations.
Your Honor, the applicant is apprehensive that these respondents might use this position to interfere with the witnesses who are yet to give their side of the story, and as far as this investigation is concerned. Then I wish also to reiterate paragraph 18 of the replying of the supporting affidavit, that apart from the two societies that have been mentioned, there have also the respondents is alleged to have swindled money to other people through other societies and companies, Common Ranching and Housing Limited, and also New Ayuma Money Kenya Company. Your Honor, so it is not just for these two that have been arrested, there are many others, and they are apprehensive that they will lose their position since they are court of appeal case in which they are pursuing with respect to this. Your Honor, there's no stay, and the court allows for concurrent civil and criminal proceedings. And nothing has prevented the applicants from pursuing this investigation, just so to speak. Your Honor, this matter before this court is alleged to be a conspiracy in which, apart from the respondents, other parties are in play. It is believed that even local administrators and government officials are involved. And since there are forgeries which have been identified, the applicant is apprehensive that the same people could be compromising as far as this investigation is concerned. Your Honor, the respondent who is claimed to be unwell, there are no medical documents which have been provided before this court. To support that allegation. And Your Honor, for those reasons, I will finally just reiterate the application and pray that our application be allowed as well. Your Honor, I just also got a glimpse of the charge sheet, even made this file presented to me this afternoon. Your Honor, how it operates is that once investigations are commenced or finalized, the file is presented to the auditor for a decision to charge the law. So even if there was a charge sheet and the file was presented this morning, this is just an observation I'm making, Your Honor, because I do not have the facts. I do not have a charge sheet before me which has been approved by the deputy, and I can only assume that the decision to charge has not been made, hence this application before this court. So probably there are some areas which need to be covered, and that's why the custodial orders were applied for. The date of this application is today, Your Honor. It was received even in our office on 23rd. And even if there is a hold in charge, it is also procedure for the investigating officer to record the respondents' statements under caution, just as a matter of procedure, as per the directive issued by the deputy.
Admitted this is an ambush. We have not even had service of the application. Up to now, even as I sit here, they are still holding it, so we don't know how we are even responding to an application which has not been served upon us. So we want the court to take note of that. And it's a good statement that there's no reason to bring the respondents at this point because they are not even ready. That is all.
I can render an opinion, might be on Wednesday. That is just the reality that I'm faced with, because I was not, and as you can hear, she's saying she was just given the file this afternoon. So I think on the whole, none of you were prepared for this application, either the defense or the prosecution. So you'll have to bear with us and allow us to look at this thing maybe tomorrow. Then maybe we come back on Wednesday in the afternoon and see if we've been able to make some progress on the issues that have been raised by both parties. That is my request. It's okay.
Like you said, this was an average, so you kindly bear with us when we don't look at it organized. Your Honor, the first Julius Alex Charles car, when the
Police station, ideally. It wasn't left on the highway.
Ideally.
So we can adjourn to the 25th of October for ruling at 2:30 kindly. Yes. So maybe they'll remain in custody with my normal course list.